This is by far the largest turnout we've had for one of our third Tuesdays. Thank you, Rod. We appreciate it. So for those of you who knew or don't know me, my name is Greg Ames. I'm the president of the Dartmouth Club of the Upper Valley. If you aren't getting our newsletters, we send out periodic emails to all of the alums in our catchment area, which kind of goes up, not quite sure how in Vermont, down to New London. There's about 3,500 alums in the area. We're actually classified as a metro club on the by size on par with LA, New York, Boston. But if you're not an alum and you haven't been getting our newsletters, there is a sign-up sheet where the name tags were. So if you fill up where Boomer just waved, I'll add you to our email list. So upcoming events, school year's winding down. We have our annual meeting and dinner at Sawtooth on Thursday, May 22nd. So that's actually not a third Tuesday, it's the third Thursday. Sawtooth was booked on Tuesday, so we had to take Thursday. That is going to be, tickets are $50 for members, discount rate for young and recent alumni, and non-members it's $80. Let's see, John, are you here? Where are you? John Engelman, everyone by the window. John is the director of the info booth. So that white booth on the green where people stop and ask, like, where's the Dartmouth sign? John, where is the Dartmouth sign? John is looking for volunteers for the info booth this year. So either sub shifts, or if you like a morning or afternoon shift, a scheduled shift. It's a great opportunity to hang out, meet new people, chat about the college. John, do you want to add anything?
We always like local alumni who know the college and the campus very well, and we're looking to the volunteers. So if you're interested in studying some kind of meeting interesting people, come to the Upper Valley. And waxing nostalgic about your own government experience, please contact me. I'm trying to think how you should contact me, either via email or telephone. And in the next last email that Greg sent out, I'll make sure he has that contact information.
If all else fails, president@dcuv.org will get to me and I'll pass it along to John. And if you're going to email president@dcuv.org, we're also looking for new board members. So if anyone is interested in joining the board in any capacity, just helping out, organize events, it's really as much of a commitment as you would like it to be. But we're certainly looking for new board members, and I'm eager to hear from anyone who would like to help out. Bob asked to give a little pitch for Rotary, and since he helped organize this, how could I say no?
Thank you. Well, we're in the same boat. We're looking for new members, which is the reason I'm here. If the Hanover Rotarians who are here would raise their hands, please. I'll show you, there's a pretty good overlap. A number of us are members of DCUV. I'm a former member, I'm a former board member, a former president, so I know how hard it is to get people to help do things. But we're here for Rotary. It's been historically connected well with the college alums and staff, and we're keeping that up. We're celebrating our 100th anniversary in a couple of weeks. There are 46,000 clubs worldwide, which total 1,400,000 members. We currently have 56 in our club, and we're up from the low during COVID of 42. But when I joined the club 26 years ago, there were 115. So we're about halfway back to getting up to our full subscription. We meet twice a month, the second and fourth Wednesday at 11:45 at Thayer Hall for you old timers, or 53 Commons as they call it now. Terrific lunch. We have fantastic speakers. President Smolla spoke to us last month. Danny Blanchflower is going to be with us May 27th, I think. So anybody who knows him can appreciate what a wonderful presentation he'll give us on all kinds of things. Most people don't know really much about Rotary if you didn't have a family connection. But our guiding motto is service above self. So we try to promote goodwill and fellowship in our community, which is at large. A number of us live in Norwich and Hanover, and Lebanon has a club, but we have a few folks who live in Lebanon as well. Our activities are designed to raise funds for Hanover Rotary Charities, which is a sister organization we have. We fund local small charities and some larger ones. Our bell ringing experience on Main Street and at the co-op has helped us raise $100,000 over the last 2 years for the Listen Heating Helpers program. It requires a lot of work, but it's a whole lot of fun.
Mention the pancake breakfast.
I shall, Ginia, give me a chance. And that's the kind of members we have. They're not shy, they're happy to pitch in. Ginia is a former president of our club. We provide college scholarships for Hanover High School students. We have support for exchange students who come to Hanover High School. We have international service projects, which include clean water programs and other health issues, as well as the goal to eradicate polio worldwide. We teamed with the Gates Foundation about 15 years ago, and with Gates Foundation, I think we raised $1 billion. And we were very, very close, not quite there, but Rotary is not giving up. It now has a $2 billion endowment that is available to help fund projects like that. We assist other organizations locally who need help. We man a barbecue stand on the green for the 4th of July parade. We used to help with the Hanover, with the Ockham Pond Party. If we get cold weather again, we might be back there. We have some galas occasionally. They require a ton of work. We raise a lot of money, but it's just such a big project that it's not in our near future for the next year or two, probably. At Rotary, we have what we call, it's famous for having a 4-way test. Is it the truth? Is it fair to all concerned? Will it build goodwill and friendship, and will it be beneficial to all concerned? So like Dartmouth, we're not a club of old guys who sit around doing deals. We're trying to help move society forward, like the colleges, like DCUV is. We have a great website, HanoverNH.Rotary.org. There's a lot of information on it. Nan Carroll, who is sitting here, does a beautiful job with our club bulletins. They're accessible on the website, or you could contact us and we would be happy to subscribe you. So like Greg's pitch, we're always looking for people who would like to get more involved, know what's going on in their community, and give it a chance to do something about it. So thank you very much.
When's the pancake breakfast?
Pancake breakfast is a week from Saturday. I got another Ginia at home, so
All right, well, folks, again, thanks for coming. I'm going to be just quickly introduce our speaker. Rod Smolla is the president of the Vermont School of Graduate School, Vermont School of Vermont Law and Graduate School.
Thanks.
He said he didn't need a long introduction, so you didn't come here to speak, so I'll let Rod talk.
Thanks, Greg. It is but a small college, sir. Yet there are those who love it. And you can count me, along with Daniel Webster, as among those who love it. It's been a delight to be your neighbor for the last 3 years, working in South Royalton at the Vermont Law and Graduate School, living a bit down the road in beautiful Stratford, Vermont. And it's been wonderful to visit Hanover and Dartmouth constantly. I'm here, it seems like, a couple times a week for this or that event, many events at the college. I've been a guest professor in courses here, and it's wonderful to be with you here tonight. I'm going to talk about the Constitution and the Presidency, and let me begin with a lawyer's caveats and provisos and fine print. This is not a partisan talk, so I am not here either to praise Caesar or to bury him. I'm not here to either advance the agenda or the values of President Trump or to attack them. I'm not here to look at the constitutional provisions we'll be talking about from a Republican perspective or a Democratic perspective. I'm here in my personal voice as a person who has been teaching constitutional law for 40 years at, believe it or not, 12 different American universities. And I've also been a litigator in state and federal courts around the country. I've had the good fortune to argue constitutional cases across the United States, including the U.S. Supreme Court. And I'm going to talk to you tonight, as much as I can, objectively, about some of the very, very significant principles currently in play regarding the presidency. Now, when I teach constitutional law and we talk about the presidency, there are some half dozen or so, to say the least, different issues that we talk about and explore. I'm only going to talk about two of them tonight. I'm going to talk to you about executive orders and the constitutional rules of the game that constrain a president's power to issue executive orders. And I'm going to talk to you about the removal power, the power of the president to fire people. There are other things we could talk about, but those are the two that I'm going to focus upon. I chose those two hoping you'd find them engaging and interesting, particularly in light of all of the swirl of events of recent years and recent months. So let me first talk about executive orders. And the way to understand what a president is allowed to do when the president issues an executive order is to examine what we know about when we have been told a president cannot do something. So in knowing what is beyond the executive power, we understand what is within it. There are two ways to attack a presidential executive order. And I'm going to talk to you about both of them. The first and the simplest is to say, we're not challenging you, Mr. President or Madam President, on your power to issue orders in this arena. We give you that this is within your portfolio. This is the kind of thing that presidents have the authority to issue orders on. But what we're saying is, you've stepped over a line forbidden in some other part of the Constitution. You violated some other constitutional clause. You violated the equal protection concept. You violated freedom of speech. You violated freedom of religion. You violated due process. And that other provision puts the kibosh on what you've done. So that's one classic line of attack, and I'll explore that with you. The other is more primitive, more raw. The other is, we're challenging your authority to even go there, to even purport to issue an order in this arena at all. You don't have the authority to do this, period. That's a harder area. That's going to require more thinking caps, but we'll get to that too. So let's first talk about that first arena in which the president issues an order. Everybody agrees you have the presidential power, but we're claiming it violates some other provision. The most famous case involving this, in which the Supreme Court said, we side with you, Mr. President. You do have the ability to do this, and we're not going to overturn it. And then history reversed that, is a case dating back to World War II, Korematsu versus the United States. Korematsu versus the United States involved the episode in which President Franklin Roosevelt issued an executive order ordering the internment of Japanese American citizens in internment camps that stretched from the West Coast to St. Louis on the theory that an American citizen of Japanese ancestry posed a threat of sabotage or espionage because we were at war with Japan during World War II. Of course, you instantly say, I don't remember Italian Americans being put into camps. I don't remember German Americans being put into camps. Only Japanese Americans were put into camps, yet we were also at war with Germany and Italy. That internment of Japanese Americans was challenged in the Supreme Court of the United States, and by a 6-3 vote, the Supreme Court sided with President Roosevelt. 3 eloquent justices dissented, saying, this is horrible, this is racism, you didn't intern the others, these are American citizens born on American soil, there's no evidence that they pose a threat, but they lost. Now, history reversed the decision. Over time, the American people of both political parties, realized this was a disgraceful moment in American history. Under President Ronald Reagan's presidency, the United States apologized to everyone who had been interned and to their families, actually issued reparations, financial reparations to those, and then later, a few years ago, in a case I'll talk to you about called Trump versus Hawaii, this United States Supreme Court said, Korematsu is repudiated, it is overruled, it was wrong when it was decided, it is wrong now, never again would we permit such a thing. So if a future president or a current president were to order American citizens interned based on their ancestry, their race, their religion, absolutely it would be overturned. It would be a valid executive order because it comes pursuant, arguably, let's say, to the Commander-in-Chief Clause. That's what President Roosevelt invoked. But for sure it would be overturned for violating equal protection. Similarly, everyone knows the president as commander-in-chief can issue rules for the armed forces. But if a president were to say, I think we'd be better off going back to a segregated armed forces. Let's have a black army and a white army, like was once the case in the United States, and that they shouldn't serve together. It would be within the president's commander-in-chief power, but this Supreme Court would vote 9-0. No, you're crazy. Separate but equal has been overruled. That's blatant race discrimination. You cannot do that because the Equal Protection Clause interdicts. A number of the president's current executive orders are currently under attack in lawsuits around the United States based on this first line of attack. So, for example, the president has attacked and taken punitive measures against a number of American universities. Most notably yesterday, Harvard, freezing $2 billion and claiming the administration will attempt to revoke Harvard's tax-exempt status. Now, was this an old Yale football player? That's the only reason I got into Yale, as a football player. And some of us may be thinking, good night, poor Harvard. But Harvard and the other American universities that are fighting this are saying, your executive order violates freedom of speech, violates academic freedom. We don't care whether you think you have the right to control the purse. You don't have the right to do it in a way that violates freedom of speech. Similarly, as you know, a number of the most prominent American law firms in the United States have been attacked recently by this administration. Some of those law firms have acquiesced and done deals with the administration. Some have fought back. 2 very prominent litigation firms, Jenner and Block and Sussman Godfrey, have fought back against it. I should confess, I was associated with Sussman Godfrey. I was one of the First Amendment lawyers on behalf of Dominion Voting in its very famous case against Fox News. I argued the cases for Dominion in the Delaware courts. So with that disclaimer, we don't know if the law firms will win or the law firms will lose, but their theory is it doesn't matter whether you think you have executive authority to decide who the government's going to do business with. You can't do it in a way that violates some other constitutional right. In those cases, the right to counsel, so the Sixth Amendment right to have a lawyer, and the concomitant right of the lawyer to represent the client, and then also free speech, also the idea that we have a free speech right to decide the cases we want to litigate and the causes we want to represent. So those are examples right now of these sorts of issues being in play. So I said you had to wear thinking caps. Now it's going to get harder, all right? So in a way, that first line of attack is easy enough to understand. Second one is much harder. Second one is a challenge to the raw, basic power of the president to even issue the order at all. So what do we know about this? Well, it turns out we have a really interesting, stylized, well thought through way of thinking about when a president has the authority and when a president does not. And it dates back to a case that is now some 73 years old, another case from that World War II, Korean War epoch, a case called Youngstown Sheet and Tube versus Sawyer, a case that has the nickname the Steel Seizure case. So this case arose during the Korean War. My dad, a Nebraska farmer, fought in World War II in the Navy, came back to Nebraska, was now being trained to be an air traffic controller. This was a new thing. Joined the local National Guard because they had a good bar and good pool facility, you know, pool. And lo and behold, he got called up and had to go to Korea, all right? At the height of the Korean War, steel workers in the United States, this was at a time of the height of the power of American industrial unions, steel workers went on strike. And you could see why. Because we needed steel production to prosecute the Korean War, so they had a lot of leverage if they were going to suddenly shut the steel mills down. There were negotiations, it was an impasse. The strike was going on. President Harry Truman said, I got this. He issued an executive order in which he seized the steel mills. That is to say, he stroke of a pen, steel mills, you're now owned by the United States. We're going to tell those workers to go to work. We're going to find them. We're going to stick them back in the mills. And if we have to, we're going to call up the Army, and the Army guys can run the steel mills. Instantly, a suit was brought challenging the president's power. That suit, from the time it was filed to when it was heard in the Supreme Court to when the Supreme Court made a decision, only took about 4 weeks. It was extraordinary. As a very young lawyer at a big law firm in DC, Covington and Burling, I listened to the lore of the lawyer who argued the case. It was mesmerizing. In a 6-3 decision, the Supreme Court said, President Truman, you have no authority to issue this sort of executive order. 6-3, 3 justices thought, you're the commander-in-chief, we're at war, you can do whatever you want, but 6 went the other way. The simple theme of the 6 justices was, hey, we got a simple system here. Congress makes laws, the president executes the laws, the judiciary interprets the laws. President, you don't get to make laws. You can't just make up, I'm going to see something and do it. There's no act of Congress giving you this authority. That's a simple way to understand it. Middle schoolers could understand that. And if they can, we can, right? But what emerged was one of the concurring opinions by Justice Robert Jackson. So in the way the Supreme Court operates, there's often a majority opinion, but then some of the other justices will chime in. They may agree with the majority, but they write on their own to say something. And every once in a while, one of those opinions becomes the dominant framework. And that's what happened here. It was written by one of my favorite Supreme Court justices, Robert Jackson. So I'm going to give you his analysis, and I'll talk a little bit more about him. Here's his analysis. He says, you can take any executive order, and you can put it in one of 3 categories. At the top category would be when the president acts pursuant to an act of Congress that authorizes the president to act. So Congress has said, you can do this stuff, and the president says, okay, I'm going to do it. And Robert Jackson says, at that point, the president's power is at its highest. In fact, in international affairs, he says, it may be the full sovereignty of the country that is now residing in the president. Then at the bottom, he says, well, what if Congress has forbidden this? What if Congress says you cannot do this? You cannot impound money. You cannot change the status of Jerusalem in how it will be represented on a passport. Now, Robert Jackson says the president's power is at its lowest ebb. Not necessarily zero, but at its lowest ebb. Finally, he says there's a situation in the middle. He called it the twilight zone, you know, no, the twilight zone, all right? And here, sometimes the president wins, sometimes the president loses. For the president to win, the president's got to point to something in his inherent constitutional authority that authorizes the president to do this. So those are the three levels. By the way, a quick sidebar on Robert Jackson, why he's one of my favorites. First, he had a lot of courage. So he dissented in Korematsu versus the United States. He was one of the people that said this is wrong. Second, he didn't go to law school. I love that. He went to, and yeah, I shouldn't say that probably, right? But he went to 1 year to the Albany Law School, then he read for the law. He's the last American Supreme Court justice to have read for the law as an apprentice. But it shows you what you can teach yourself, all right? Because I also love him because he had extraordinary style. He was a magnificent writer. He wrote with the grace of F. Scott Fitzgerald or Ernest Hemingway. I mean, he beautiful, beautiful prose, which is one of the reasons his opinions came to dominate. Finally, fascinatingly, it's hard to imagine this happening today. After World War II, he took a leave of absence from the Supreme Court to become the chief American and Allied prosecutor at the Nuremberg trials. What a fascinating thing. See you later, Chief. I got to be gone for a year. I'm going to leave the Supreme Court. I'm going to go prosecute in Nuremberg. Then I'm going to come back and take my seat. Some of the other justices didn't like that. They thought it was unseemly, but he did it. And of course, he was famous for his speeches at Nuremberg. The only other time that that's happened in American history, some of you know, Earl Warren took a side job to run the Warren Commission to investigate the assassination of John Kennedy. Hard to imagine a Supreme Court justice doing something like that in these times, but those are two famous examples. Before I leave Justice Jackson's 3 tiers, let me tell you how I teach this when I teach constitutional law. So I try to make it easy for the students. Some of you may remember there was once a movie called Rocky. Most of you are too young. You remember Rocky 3, 4, 5, 6, 7, Creed 1, 2. I think there's 9 Rocky movies. But believe it or not, way back at the time of the framing, there was a Rocky 1. And there's a beautiful moment when Sylvester Stallone is talking to his sister, and he says, "It's simple mathematics. It's simple mathematics. You hang around with yo-yo people, you're going to have yo-yo friends." That's how, right? Simple mathematics. Here's Justice Jackson's theory, simple mathematics. When the president acts pursuant to a delegation from Congress, you take all the powers of Article 1, that's the powers of Congress, you add the powers of Article 2, that's the presidential clause, and you get a 3. When the president acts alone, you only got Article 2, you get a 2. When the president acts and Congress says you can't do it, you take 2, you minus 1, you get a 1. 3, 2, 1. It's simple mathematics, all right? It's a little impish, but it works. Now, do we know the result every time? I don't know that there's a clear case in American history. In fact, I know there isn't any case in American history in which a presidential act in that highest category has been struck down as being beyond the powers of the president, but there are examples of it being struck down for other reasons. The repudiation of Korematsu would be an example. Are there any times when the president is at its lowest ebb? We're in that bottom category, but the president still wins? And the answer is yes. One of the famous examples, I alluded to it vaguely earlier, Barack Obama won when Barack Obama and his administration followed what had been consistent foreign policy about how to designate on a U.S. passport a person born in Jerusalem. Because the status of Jerusalem had been a matter of international dispute, the executive branch had a particular view as to how that should be stated on your passport. Congress said no, and the U.S. Supreme Court sided with President Obama, saying that is exclusively within the powers of the president. Congress, you can't intervene at all, you can't subtract from it. A rare example of that. And then there are cases that come out in the middle in which it could go either way. Before I move on to the firing power, let me talk about how I think these cases involving the attack on the president's power will turn out in the current state of play. We have some clues. First, at least when it comes to international matters, foreign policy matters, I suspect if the president can point to any statute of Congress that even vaguely seems to authorize what the president will do, the president's likely to succeed. The test case we have, the scouting report case we have, involves President Trump from his first term. And one of my students here, Tracy Gunyon, will hear this for the second time today because we talked about it today in constitutional law class, in our First Amendment class. The case involves President Trump's immigration ban in his first time as president. As you remember, he ran for president saying, among other things, he would put into place an anti-Muslim ban. He would ban Muslims from coming into the United States. He then became president and delivered on his promise, issued a ban, and within hours, federal courts held it was impermissible. That even though you have powers under the Immigration Act to ban people from coming to the United States, this was a violation of the religion clauses. He then tried a second time. That second order also had religion in it. Once again, instantly struck down by federal courts. He didn't appeal. He then did it a third time. Third time he did the executive order. This time, his lawyers were much better. No mention of religion at all. And on top of that, 2 additional countries were put on the ban list, Venezuela and North Korea, neither of whom have any significant Muslim populations, so it took some of the oxygen out of this being a Muslim ban. This is a routine foreign policy ban. In that posture, the case went to the Supreme Court. The Supreme Court, first of all, said, we say this is within your power. This is at the highest ebb under Justice Jackson's analysis because Congress already had in place a law that says presidents, you can, for national security reasons, not allow people into the country, so your power is at the highest ebb. What about the idea that it violated religion? 5 justices said it was okay. 4 said they would have struck it down as an anti-Muslim ban. The interesting issue was the ban in front of the court on its face looked clean. Didn't mention religion, didn't mention Islam. It seemed to be a regular executive order. People from these countries can't come in. But everybody knew he'd been talking about a Muslim ban. So the challengers and the dissenters said, come on, he's been saying anti-Muslim, this is what happened. Of course, and the first 2 tries were clearly that. Of course, in an opinion by Chief Justice Roberts, the court said, we don't like what the president said. He actually said that in the opinion. This is very un-American, the things he said, but that's not our business. It's not about this president, it's about the presidency, and we're not going to infer an illicit motive based on what he said as a candidate, at least in the area of foreign affairs. So I predict the president will win there. As to the other challenges currently percolating, there are something like, I'm not making this up, 150 current pending lawsuits. Can you imagine? So, I mean, this is going to take some time. These are going to start to reach the Supreme Court. I think you're going to be surprised. That's my prediction. So some of you probably on betting apps, and you bet on the Super Bowl, whatever. If you got a Supreme Court thing on there, all right, this is me giving you the odds, all right? Don't make the reflexive assumption that a conservative Supreme Court, 6 relative conservatives, 3 liberals, will automatically side with President Trump. Don't make the assumption that the 3 appointees from President Trump's first term will necessarily side with him. Here are the counterpoints to that. They will on one issue, which I'll get to, but not on all of them. First counterpoint, this is a surprisingly pro-free speech Supreme Court, and that tends to cross ideological lines. You could make the argument that the strongest pro-free speech justice in all of American history is the current Chief Justice John Roberts. And several of the other conservative voices are as well. So some of these bans, some of the things like you lose your money if you teach DEI, you lose your money if you litigated against us in something, I think may be a bridge too far for some members of this court. I don't know, but I wouldn't be surprised. But now let's talk about that other issue, the raw presidential power. You might be thinking, oh, these folks are for surely going to side with President Trump. After all, they wrote the presidential immunity decision. They believe in a strong presidency. He's going to be on a roll here. And here's my thinking, not so fast. Because interestingly, one of the pet causes of several of the conservative justices, and a long-time pet cause of a lot of conservative legal intellectuals, has been that you should have a narrow view of the power of Congress to delegate authority to the president, and a narrow view of the president's authority to exercise executive orders in the absence of a clear delegation. The conservative court used that multiple times to strike down executive orders of President Biden and decisions of the Biden administration. It used that doctrine, sometimes it's called the non-delegation doctrine. You can't delegate vast authority to the executive. Sometimes it's called the major question doctrine, which is if it's a big deal, you better have Congress's authority behind you. You can't just do it on your own. They're jurisprudential cousins. They're the same thought. That was used to overturn many of the regulations President Biden issued during COVID. The court saying, these are too big a thing for you to have done without a clear act of Congress. It was used to overturn the decision of the Environmental Protection Agency to issue rules for cleaner energy, saying Congress has debated this for a long time. It's never been willing to pass a law doing this. You can't just do a switcheroo on your own and decide we're going to change energy policy. You got to have an act of Congress behind you. And it didn't in the student debt case, Biden versus Nebraska, where the court said, you can't just, with a stroke of a pen, cancel, billions of dollars, $400 billion of student debt. You got to have a law that clearly says you can do that. You don't. So if this court plays it straight and calls it as it sees it, it's going to go against President Trump on some of these assertions of authority because the court will decide this is too big a thing for you to do without congressional participation. Now, he may be able to get it. He may be able to go back to Congress and they'll do it. We'll see. But I think you'll be surprised as to what the court will do there. Which leads me to my final topic, the firing power. All right? You're fired. All right? So this is a fascinating question over the extent to which Congress can limit the authority of the president to fire high-ranking federal officials. So let me give you the story a little bit. I'll tell you where we're going. There was a decision just a couple days ago, and I'll give you my prediction. So here's what the Constitution says. It's got a lot of stuff in there about how you get appointed to federal office. There's all these rules, principal officers have to have the advice and consent of the Senate, all these ways you can become a federal officer. But surprisingly, nothing much about who gets to fire people. They do talk about impeachment. There's a couple impeachment clauses. That was a big one, obviously. But after that, it's silence. It's kind of, the framers were great, but they missed a few things, all right? It's like one big thing they missed, my favorite is, the Constitution doesn't tell us how many justices are on the Supreme Court. That's kind of weird. I mean, it tells you exactly how you compute the House of Representatives, exactly how you compute the Senate. We got one president, we got one vice president, but there's no like, it's supposed to be 9 or it's supposed to be 7. You'd think you would have put that in there, right? Most state constitution did. It's like saying we're going to create this new game, we're going to call it basketball. And you just put however many players you feel is right out there, right? You know, kind of weird. And it's caused us a lot of turmoil. But they didn't think about the firing power. I guess those guys never imagined themselves getting fired. I mean, it's like, you know, hey, nobody's going to fire Benjamin Franklin. I mean, you know, it's like they never thought about, you know, somebody will want to give you the axe. So it was uncertain. And it was uncertain for a long time until 1926, when the Supreme Court issued an important opinion called Myers versus the United States. So I know there's a wine bar out there, so this you can amaze your friends with trivia the next time trivia comes up at one of your local bars, all right? Let's see if you can answer this constitutional and American history trivia question. Who is the only person in the history of the United States to be both President of the United States and the Chief Justice of the United States? William Howard Taft. You got it. William Howard Taft. And he was the author of this opinion in Myers. And he said, it's true the Constitution is silent. And then he wrote this huge opinion, 80 pages long, went through the whole history of executive powers and sovereigns to fire their subordinates. I mean, I think he went back like to Caesar Augustus or something. He has long scholarly opinion. But the gist of it was, he says, you can't function as president unless you can fire your subordinates. They got to be loyal to you. You got to be able to fire them at will. And any attempt to interfere with that violates the Constitution. In the particular case, the official was a postmaster. And Congress had passed a law saying, if you're a postmaster, like first class, second class, third class, I think it's kind of like It's a Wonderful Life. Remember Clarence was angel second class, he was trying to graduate, you know. So this was a postmaster. Woodrow Wilson wanted to fire him, but the law said you couldn't fire him. And in this famous opinion, Chief Justice William Howard Taft said, that violates the Constitution. Justice Jackson's opinion had not been written yet, okay? But you can think of it as sort of this. Even though it fell in that bottom rung, even though Congress had said you can't do it, this was one of those things that the court said, that's got to be within the inherent exclusive power of the president, okay? So that was the rule for a long time. Then, as so often happens in constitutional law, the Supreme Court backtracked a bit. And so it was after that period, starting actually with Herbert Hoover's administration, but just then taking off like a rocket during the Roosevelt years and then during the Lyndon Johnson years, the federal government got gigantic. So if you go to Washington, I go there all the time, my daughter lives there, I love to go to Washington. You know, you go to building after building after building. You see these majestic federal buildings, all these federal agencies. A lot of them, however, are what we call independent federal agencies. Strange creatures. The Federal Trade Commission, the Federal Communications Commission, the National Labor Relations Board. And these are agencies not run by one boss. They're not run by one Attorney General or one Secretary of the Treasury. They're run by multi-member commissions. Might be 5 members, that would be common, might be 7. And those are commissions in which there's job security, a term of years, often 5 years or more, because Congress wanted them to straddle presidential terms. And you can't remove them if you're the president. They're generally beyond, they're told you're not beyond the power of the president to remove. And the theory behind this was, it's kind of weird, the theory behind this was, these aren't purely executive agencies. These are quasi-judicial agencies. They judge things. These are quasi-legislative agencies. They make up rules. They're a bit executive, a bit judicial, a bit legislative. Now, a lot of people thought this was ugly. This was like Quasimodo. I mean, this is an ungainly thing. Where in the Constitution does it say you could do this? But it was accepted. And the theory that caused it to be accepted, it's a very New Deal-y kind of theory, is we want the government run by experts. And we don't want them buffeted by politics. We want them to be safe in their job security. We want the Federal Reserve Board to make decisions based on economics. We want the Federal Trade Commission to make scientific, objective decisions. You know, we want the FCC to do the same. We want all these agencies. So we're going to give them a lot of power. We're going to immunize them from the buffets of politics. We're going to immunize them from the caprices of presidents. And they're going to wield great authority. This has always been something that rankled certain scholars and certain members of the legal community. It's particularly something that has often rankled conservative intellectuals, many of whom are friends of mine, and I've talked to about this. And they think this was an incursion on the Myers case, on William Howard Taft case, which they think deserves extra weight because he really knew what he was talking about. He had been president. And he said, you know, I'm the guy who was president. I tell you, I got to be able to fire people. Or if you want a pun, extra weight, because he was famous for his girth. Famous myth that he got stuck in the White House bathtub, all right? I think it's a myth, but anyway, he had an exercise bathtub built. We do know that much, all right? So this has been something that they've wanted to see changed. President Trump came into office and began firing these people that legally he's not supposed to be able to fire. He's fired members of the National Labor Relations Board, fired members of other federal agencies. They have sued, claiming this violates this body of law allowing job security. You'll see in the news, maybe if you really, you'll see in the news some of the famous cases that upheld the powers of Congress to do this. One is called Humphrey's Executor. Humphreys was one of these guys that got fired. He then died. His estate sued. And the court said, President, you don't have the power to fire him. He's one of these independent agency guys, the Federal Trade Commission. Another case called Morrison versus Olson you may see in the news. I believe this Supreme Court will side with President Trump, will say that these independent executive agencies are unconstitutional, will say the president must have the power to fire these commissioners, will go back to William Howard Taft, and will give a win to the president on that line of attack. The issue was decided a few days ago by the United States Court of Appeals for the District of Columbia Circuit, a case that I've argued in front of a lot. By an 11-4 vote, they said, you can't fire these people. The law of the land is still Humphrey's Executor, that case that I mentioned. But they also said, we're just doing this because if you're going to overrule that case, Supreme Court, it's your job. We can't overrule you. You got to make that decision. So it's teed up, in my view, and I suspect you'll get something like a 6-3 decision overturning those cases. So with that, I'm done. You've been a patient audience. Thank you so much. And I'll be happy to take questions later. Thank you. I'll take a few questions, yeah?
Recently, in the last couple of hours, President Trump has threatened to revoke Harvard University's tax-exempt status.
Right.
I assume that has to go to Congress. Congress has to pass legislation doing that. The question is, can they target just Harvard University?
Yeah.
Or does this involve every private university?
So if the contest is over whether it's legally permissible to suspend Harvard's 501c3 status, its charitable status, because of Harvard's position on things like diversity, equity, and inclusion programming, then that raises a First Amendment issue. And although the precedent might technically bind Harvard, it would affect Dartmouth, it would affect every public and private university every private university that has charitable status. There is a case involving the revocation of that status. It's called Bob Jones University versus the United States. Bob Jones University is a conservative evangelical university in Greenville, South Carolina. It practiced segregation. It would not admit students of color. It eventually relented there, but would not allow students to date interracially. And so it was acting as a private school in defiance of principles of equality such as Brown versus the Board of Education. The IRS revoked Bob Jones's charitable status on the theory that among the IRS regulations is that you must operate in the public interest. I don't remember the exact tax code rules, but operates in the public interest, not contrary to public policy, something like that. And in a US Supreme Court opinion, the Supreme Court sided with the Internal Revenue Service against Bob Jones and upheld the revocation, all right? Now, does that mean Harvard will lose? Not in my view. In my view, Harvard deserves to win. Why? Because the things that Harvard is being penalized for, in my judgment, can't be construed as illegal. And the reason I say that is, even though the case 3 years ago involving Harvard, Students for Fair Admissions versus Harvard, said it violates the Constitution and a federal law for you to engage in race-conscious admissions, so it overruled affirmative action. It's a far cry from saying affirmative action is impermissible discrimination to saying that teaching courses on issues such as racism and diversity and equity and inclusion and so on, that's discrimination. That's different. That is academic freedom. That is teaching things. That is giving students things to read. That is provoking discussion about these issues. And that is a core First Amendment value. And there are Supreme Court cases that say, even when you're the recipient of largesse, even when you're the recipient of money or some other benefit, because basically the exempt status is a tax subsidy, you can't condition the receipt of that subsidy on the surrender of First Amendment rights that you would otherwise enjoy. It's a complicated body of law, but that's the baseline rule. And the person who said that most forcefully is John Roberts. So I suspect there will be a challenge. I'm hopeful that Harvard wins. It deserves to win. It is one thing to say affirmative action is no longer permitted. People can debate that. Quite another thing to say, you can't talk about these issues. And to me, that crosses a faithful line. And Daniel Webster would back me up on that. Because even though the Dartmouth College case is technically a corporate law case, it's really an academic freedom case. And if you read the opinion by Chief Justice Marshall, who, by the way, in lore, wept when Daniel Webster made that as part of his peroration, and he wasn't that emotional a guy, all right? But if you read it, it's really an academic freedom case. It's really a case saying the Board of Trustees of Dartmouth have a right to decide for themselves what Dartmouth will do. There can't be a hostile takeover by the state of New Hampshire. This is the point. Chief Justice Marshall used a great old word we don't use much anymore, eleemosynary, which is sort of to your point. And the eleemosynary, the charitable corporation of Dartmouth College, should decide for itself how it wants to conduct instruction here. And geez, I wish I got to argue the case for Harvard. I'd bring that up. I'd bring up Daniel Webster. A couple more questions, and I'll be happy to take questions as we mingle, because I don't want to have people feel I have to stay too long. I'll just sweep through the room left to right.
Well, you actually just brought it up, but I guess you started out with Daniel Webster's famous statement about the college in front of the Supreme Court. I'm wondering, and you have alluded to this, but do you think that the Dartmouth case has a bearing on the current state of the government trying to tell colleges?
Yes, I do. I do. That's why I brought it up. There obviously have been so many modern cases since that deal with the rights of universities and that deal with academic freedom. And they come out somewhat different ways. The issues are complicated. But if I were writing a brief in the case, I would hearken back to that as the first great statement of that. This court loves history and I would quote it just for that. I don't think there's any Dartmouth graduates on the court right now, but
What if the president simply ignores Supreme Court decisions and uses his pardon authority to protect his secretaries from contempt proceedings?
yeah. So I think I tried to say at the beginning, I'm trying to make this a nonpartisan talk. You are leading me, but I think the question is, let's imagine the president issues an order to disobey a court order. So orders the Secretary of State to disobey court orders trying to return the citizen that was wrongly sent to El Salvador.
He simply ignores it as he is right now.
And a court finally takes action. A court says, you can't ignore it, you must do it by Friday. The Supreme Court endorses it, and the president ignores it. What powers does a court have? And they're limited. The contempt power is the classic power. And of course, the problem with that is that historically in the United States, we've relied on the executive branch to obey judicial orders even when the executive branch disagrees. So you know there's a famous moment, I think, in which Joseph Stalin said to the Pope has issued his encyclical, how many armies has the Pope? Something like that. And how many divisions has the Pope? And then historically, Andrew Jackson is supposed to have said, you know, John Marshall issued his opinion, let him enforce it. It's not clear he ever actually said that, just like there's a little debate over Daniel Webster, but I don't want to go there. As far as I'm concerned, he said it. But most of the time, we've relied on the good faith, on the trust, on the mutual respect, on the culture of obedience to court orders, even when one disagrees. And there have been dramatic examples. For example, Dwight Eisenhower, for all his greatness as commander during World War II, had a blind spot when it came to race discrimination. He disagreed with Brown versus the Board of Education. He once said to Earl Warren, you were my greatest mistake. He didn't think the country was ready for desegregation. But when the governor of Arkansas, Orville Faubus, tried to prevent Little Rock Central High School from being desegregated and called and talked to President Eisenhower, thinking he had a buddy in the White House, Eisenhower told him, let those children into Little Rock Central High School. The governor said, I won't, and the President of the United States nationalized the Arkansas National Guard, sent the United States Army into Little Rock, effectively occupied Arkansas, and made the Supreme Court's order be enforced, even though he personally disagreed with it. And in more recent times, Richard Nixon, who challenged the authority of the special prosecutor to subpoena the Watergate tapes. When the Supreme Court issued its ruling, he voluntarily complied with the ruling. Several days later, he resigned as president. Sadly, we're not sure that this administration will do it. And some of that obfuscation and dancing around and delaying makes it hard to get a grip on it. You may know that a federal district judge in Vermont, in Burlington, Judge Sessions, said yesterday in a hearing involving yet another deportation, if I order you not to send this person away, this is the person apprehended in White River Junction, will there be obedience to my order, or will we have a constitutional crisis? The judge put it to the U.S. attorney there. The U.S. attorney said, we'll obey the orders, Your Honor, but who knows if that U.S. attorney will prevail or not. I'll take a few more questions. I thought I saw one on the couch. I'll take a few in the back. Yes, yes, yes.
Can you talk a little bit about the pace of the different branches? You know, the executive orders are flying
Yeah.
quickly. The court system is moving at a snail's pace.
Yeah.
They make the decision, as you say, and if
Sure.
it's illegal, it doesn't matter. But if they make the opposite decision, it almost doesn't matter anyway, because you can't rebuild these.
Sure. So the question's about the pace and the fact that the executive can move extremely quickly. He's flooded the zone with all these orders. So let me say the first thing. It's not exactly true that the judicial branch always moves slowly, because one of the weapons in the toolkit is a temporary restraining order, which can be followed within 14 days by what's called a preliminary injunction. And that is the authority of the court to freeze things and to prevent the executive order from going into effect until the court can hear more, have more briefs, and so on. And in many, many of these cases, that's happened. Now, it's not a permanent break, but it's a slowdown move. And sometimes that freeze, preventing the executive order from going into effect, can last for a long time as the case goes through the appellate courts and the Supreme Court. It's a complicated body of law how that works, and sometimes the freeze stays and sometimes it doesn't stay. The Supreme Court has upheld some of those freezes. It has not in others. So there is one tool that gives the executive branch and the challengers the authority to slow things down. I agree with you. In a case in which there's not a freeze, not a temporary restraining order, then you're right. Then the injunction goes forward, people lose their funding, people lose their jobs, and it may take the judicial branch a year, 2 years to catch up with it. The way the Supreme Court operates is they've stopped taking cases right now, except if it were an emergency, they would still do one. They could still do them, but they more or less stopped taking them until next October. So where a lot of these cases are, if they're going to reach the Supreme Court, a lot will depend on this, whether the court keeps the freeze in place until it gets the case, or doesn't put the freeze in case. It may still get the case, but then to those who are challenged it, the harm will be done.
October in 6 months, not 18 months.
October in 6 months is when the case would be heard, and then it could be another 9 months before it's decided. So I'll take 2 more, and then I want to let you all get back to your refreshments, but you can come ask me questions on the side. Because as Tracy would say, when the bell rings, we get out of class, right? All right. Yes, sir.
Do you think that any of the administration's lawyers can be held in contempt in jail?
Yes. So one of the things the judge can say is, you're an officer of this court, you've told me this, you've told me that, that's not good enough, I'm gonna hold you in contempt, I'm gonna issue sanctions against you. Now, in theory, the president could pardon the lawyer, as the contemnor, but there is and most lawyers would loathe that. They would loathe being sanctioned by a court for disobeying a court order and being held in contempt. But, we'll see how that plays out.
Some of them seem to be already asking for that.
Well, I'm not going to comment, but I understand there's a lot of Muhammad Ali float like a butterfly, sting like a bee, right? Or rope-a-dope. I don't know which one.
Thank you.
It's good to end. I have one more question.
It seems to me that Trump is trying to overwhelm the court system with executive orders. The way they're organized to
Yeah.
groups.
So I think the question that I heard was just sort of this notion of overwhelming with just an incredible number, both in terms of the breadth and the numerosity of them, and that's unprecedented in American history, and to some degree it's working. I mean, to some degree it's working. And the other thing I will say is, in some of these instances, the parties affected could have put up a united front, and maybe a united front would have had more power than a divided front. So in the world of American law schools, there was a letter circulated among the law schools in the United States to protest attacks on law firms for the people they represented, and on legal clinics for the clients they took. Northwestern Law School's clinic was threatened. There are about 200 American law schools. Only 79 signed the letter. Vermont Law and Graduate Schools was one of them. I was very proud of our dean for doing that. You see the same thing with the big law firms. 8 or 9 or 10 have acquiesced. Several have fought back. I think a divided response in those situations, if I were the president, will think of those as a victory.
They're afraid of him.
Right. Can I give my law student the last question of the day? I said, you put your hand up, or if you forgot.
Well, no, I thought the gentleman was about overwhelming.
That was your question.
No, but asking
asking about, I think what you were saying was, could some of these litigations be merged in front of SCOTUS so that,
Yeah, and they have been. And the answer is they have been. So first of all, there's an inherent power if a case is filed in Iowa and a case is filed in DC and a case is filed in New York, and they're all basically similar, there is authority to combine them. And secondly, some of the cases are brought by representative groups that represent a broad swatch of people, like the Association of American University Professors and so on. And the other thing I'll say is, the way the students act is when it's right behind when the bell's about to be talked, and I ask, are there any more questions? There's a secret treaty. You're not supposed to raise your hand. It's a beautiful day. Let's get out there. You can ask a question after class. Thank you all for coming. Thank you. All right. Thanks.